Welcome. My name is Bob Brogan, President of Brogan Law Group, and I'm providing informational videos today for our clients and some prospective clients to provide some information that may be of value to you. Frequently, we will get calls from family members who are concerned because they believe that their loved one may need a power of attorney. So I'm going to talk about powers of attorney, but I'm also going to talk about guardianship. Because whether or not you can execute a power of attorney, which is a legal document designed to have somebody else provide assistance to you with financial transactions, is initially a question of whether or not you would understand what you're signing if you executed that document. We call that capacity. And legal capacity is ultimately determined by a court. You can get doctors to affirm whether or not you have capacity or you don't have capacity. And in the event that a client needs certain help or their family member needs to help them in a particular way, such as if somebody needed to move to a nursing home, for example, and they needed to sell their house, but they had had a significant stroke and can no longer manage their affairs. In that situation, a power of attorney cannot be signed if they don't have capacity. And in that situation, we would have to get two different doctors to affirm that they have lost their capacity. We call that being incapacitated. And file an action with the state of New Jersey to have a guardian appointed for them. We call that the guardian of the person and the guardian of the property, who can manage both their medical decisions as well as their personal financial decisions. A guardianship should be an application of last resort. We certainly try to maintain people's independence and encourage people to, while they are lucid, take the steps necessary to enter into a proper power of attorney so that if something happens down the road, the one person that they trust most would be the first person to act. And if they're not available, then have a successor name so that the next person you trust is the one to act. While I believe most of the judges in our state try very hard to do the best by people, I always felt that it's better for somebody to make their own assessment of who they want to make decisions with them in the event that they are no longer in a position to make them for themselves. So don't leave it to the courts. If you have capacity and you're well enough to watch this video and understand it, I do encourage you to get your power of attorney updated. Don't just assume that the one that you have satisfies all that you need. We have seen a vast majority of powers of attorney in New Jersey that do not include proper gifting language. So someone might contact an elder law attorney like me who is looking for help in providing protection for one spouse while the other spouse is needing long-term care. If there's no gifting language in the power of attorney, even though one was signed, we can't protect assets for the spouse who's home. We may have to go for a guardianship. So please, while you're well enough to do so, if you're over the age of 18, consider and follow through on getting a power of attorney done, because you don't want to have to proceed with guardianship. But if you find that somebody in your family is that situation, we'd be happy to talk with you and work through how we may be able to help. Thank you.